I am Laura O'Brien, partner at Hodge Jones and Allen and member of the youth team at Hodge Jones and Allen. And today I'll be addressing you on practice and procedure in relation to handling child witnesses for criminal practitioners. Now, to start with a rather sober warning, but it is important in relation to this topic. The Court of Appeal in Grant Murray, a case from 2017, emphasised that it's generally misconduct to take on a case where an advocate is not competent. Now, of course, that applies to all cases, but the Court of Appeal went on to say it would be difficult to conceive in an advocate being competent to act in a case involving young witnesses or defendants unless the advocate had undertaken specific training. It may well be why any of you are watching this that you already recognise that, but I think that underpins a lot of the practice and procedure that I'm going to address, that there does need to be a tailored, competent, specific approach in cases that involve young witnesses and defendants. Jumping back a bit to a specific special measure. Something that a lot of advocates will be familiar with is pre-recorded evidence. So this is pre-recorded cross-examination and re-examination of a child or vulnerable witness. And this is something that is outlined in Section 78 of the Youth Justice and Criminal Evidence Act. So not every case where you have pre-recorded examination in chief will you have pre-recorded cross-examination and re-examination. And I think, in fact, that I'd say that is the case, that the majority of cases where you have a video recorded interview with a witness, you relied upon as their evidence in chief, you won't have a pre-recorded cross-examination and re-examination. So this is not necessarily something that you will always see as a feature. It's got a different set of provisions. But witnesses eligible for this special measure should be identified promptly by the police. So this is going to apply to prosecution witnesses. The prosecutor must formally notify the court and the defence at the first hearing or as soon as possible thereafter if eligibility only becomes apparent following the first hearing. You can see the theme here. Identifying these issues early on is the only way to ensure that things run smoothly and effectively and that these rules can be properly followed without delays, bearing in mind the impact that delays will have on young and vulnerable witnesses and defendants.